Same-sex marriages. Hey, they happen, recognized in some states, but not all states. Does that create some problems? It sure does. And that brings us to this week's case. It's a case involving a same-sex couple living in New York. They decided to adopt a child. They proceeded with the adoption in New York. They adopted a child who, at the time, was born in Louisiana. Under New York law, when the adoption goes forward, the court orders, and can order, that the birth certificate be altered to show the names of the adopting parents as the natural parents of the individual, so that the child who's adopted as they grow up will always view themselves as the offspring of the parents who adopted them. Okay, fine and dandy. Court in New York ordered that, but the Office of Vital Statistics in Louisiana said, we can't do this. No, 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 we can't do this. We can't change the name because this is a same-sex marriage adoption. We don't recognize that here in Louisiana, therefore we're not going to do it. Well, the couple was very distressed with this, and they filed a case in federal court. Went to the federal district court, and then it went upward to the Fifth Circuit Court of Appeals. Spent some real-time effort, energy, and money on this case. When it got all the way up to the Fifth Circuit Court of Appeals, the court looked at this and said, hang on a second, hang on a second. You know what? Under the U.S. Constitution, we have recognized a collection of 50 states, but one of the very important things in the U.S. Constitution is the full faith and credit clause. And under the full faith and credit clause, something that's done in one state that's commonly done in another state, such as adoption, must be recognized in another state and be given full faith and credit. So the court came away and said, all right, New York, adoptions take place. Louisiana, adoptions take place. In this instance, we're only dealing with an adoption, and in this instance, you, in Louisiana, the Office of Vital Statistics, must listen to the New York court, give the New York decree full faith and credit, and change that birth certificate. End of story. So that, in fact, is what did happen, and these adopting parents got that birth certificate, which is what they wanted. But it only came after lots of time, effort, and energy. This demonstrates that when we have a situation such as same-sex marriages that are recognized in some states but not recognized in other states, there are going to be wrinkles. We've talked about some of those wrinkles in the past. It's going to involve everything from what happens if they want to get a divorce and they're living in a state that didn't recognize the marriage, what happens if one of them dies and the property has to flow through intestate succession in a state, that means without a will in a state where the marriage wasn't recognized. Boy, all kinds of problems that can arise. So it just doesn't work 1, 2, 3. If you get married in a state that recognizes same-sex marriages and you're living in a state that doesn't recognize that, there may still be some substantial problems. Sure, you might be able to get them worked out, but it only comes with lots of time, effort, and energy. All right, bringing you this so you understand how the law works, as we often say, so you can make the law work for you. I'm David Allen.